Hello, this is Dale Whitman, and I'm here to welcome you to ProfDale's Property video number 6, which is all about the fee simple absolute and fee simple defeasible estates. Let me take you back to the previous video, video number 5, where we built this chart of interests in land. What we're going to focus on in the present video is the very bottom of the chart, where we find the fee simple absolute and the fee simple defeasible. Now, there are two kinds of fee simple estates, as you can see from the chart. The first kind, the fee simple absolute, is one that definitely will last forever. Nothing can make it terminate. The other kind is the fee simple defeasible, and that's one that might not last forever because, in the words of its creation, there are some conditions that are expressed that indicate that the fee simple might come to an end, or in other words, might be terminated or extinguished in the future. That means that if we read the deed or the will that created the fee simple defeasible, we can tell what those conditions are and when it might terminate in the future. First, let's focus on the fee simple absolute estate. As we've indicated, it's one that will definitely last forever. Nothing can make it terminate in the future. And you might say to yourself, well, wait a minute, suppose the state condemns the property for a new freeway. That makes the fee simple terminate, doesn't it? But the answer is no. It simply transfers ownership of the fee simple absolute to the state. But it's the same fee simple absolute. Nothing can make it terminate. Let's go back to the Old English common law, and by that I mean the law of England as it existed perhaps in the 15th, 16th, and 17th centuries. And let's assume that O owns some land in fee simple absolute and executes a deed that says, I grant this land to A. At common law, what type of estate did A receive? Well, in a way, this is a trick question because the answer is that A received not the full fee simple absolute that O had, but only a life estate. Now, if A only got a life estate because some words were missing here, what about A's heirs? Did they have a future interest in the property? No, they didn't. Did they have any interest at all in the property? No, they didn't. The only interests that exist in this situation are the life estate in A, and when A dies, what will happen to the property? The answer is because it hasn't been further disposed of, possession of the property will go back to O. So we say that O, during A's lifetime, has a future interest in the property. Now, as we've indicated, there were some missing words in the previous example that caused O to convey not his full fee simple absolute, but only a life estate to A. What are the missing words? They're the words that you see on the screen now, and his heirs, or if A was female, it would be to A and her heirs. If those words are added, then at common law, A would receive the full fee simple absolute that O had held. Once again, did A's heirs have any future interest in the property? No, they didn't. A had the full fee simple absolute, and that's the only interest that exists. What about A's heirs having any other interest in the land? No, they had no interest whatsoever. So who would be entitled to possession of the land when A died? Well, that depends on the circumstances of A's death, and we'll look at that on the next slide. So what happens to a fee simple absolute estate when its owner dies? There are actually three possibilities. The first one is that the owner might have deeded the land to somebody else before the owner died, and in that case, the property would be held by the people or person that the land was deeded to. We refer to that individual, if there's just one, as a grantee, or there might be more than one. We call them then grantees. A second possibility is that the owner might leave the property to somebody by will at death. And the person who receives property by an owner's will at death is known as a devisee, and the clause in the will is known as a devise. A third possibility is that the owner might die without a will. We refer to that as dying intestate, and if that happens, the property will go to the owner's heir, or perhaps more than one. We'd call them then the heirs. So depending on the circumstances, the property at the owner's death might go to a grantee, a devizee, or an heir. Now let's assume that O owns some land in fee simple absolute and does make a conveyance to A and his heirs. The common law took that phrase to A and his heirs and broke it into two parts. The first part, to A, they referred to as words of purchase, and basically that means these are the words that tell who is getting the interest in the land. In this example, it's A. Don't be thrown off by the word purchase. It applies equally well even if A doesn't pay anything for the property and receives it only as a gift. Whether it's a gift or a sale, we call those words of purchase. The other words, the words and his heirs, are called words of limitation. They don't tell who is getting an interest in the land, and as we've already said, A's heirs don't get an interest in the land. They're sort of magic words, and they tell what type of estate is being conveyed. And in this case, where the words are and his heirs, they indicate that A is receiving a fee simple absolute, and they don't indicate that A's heirs are receiving any interest at all. Now today, nearly every state in the United States has a statute like this one. This happens to be the one for the District of Columbia, but nearly all states' statutes in this regard are similar. And what they say is that no words of inheritance are necessary in a deed or a will to create a fee simple estate. Every conveyance of real estate is construed to pass a fee simple estate, or whatever estate the grantor has, unless a contrary intention is expressly spelled out. So what that means then is that under modern American law, if O makes a deed that simply says to A, or if O makes a deed that says to A and his heirs, either way the result is exactly the same. Either form of deed will pass O's fee simple absolute to A. So putting in the words today, the words and his heirs, is completely unnecessary. Now there are some principles about conveying property by deeds and wills that you need to know. The first one is that there are two limitations on what is conveyed by a deed or will. The first one is you can't convey more than you have. That seems like a pretty obvious idea. The second is you can't convey more than you purport to convey. In other words, if you say you're conveying only a life estate, you won't actually convey a fee simple absolute. So if a deed or a will is silent as to the type of estate that's being conveyed, what does it purport to convey? Well, under statutes like the one for the District of Columbia that we looked at a minute ago, the answer is that the deed that is silent purports to convey a fee simple absolute. Let's take an example of this. Suppose an owner has only a life estate, but purports to deed away a fee simple. And they could do that simply by giving a person a deed that says, I convey this land to A. What will the grantee receive? Well, even though the deed purports to convey a fee simple absolute, if the owner only has a life estate, of course, only a life estate will pass to the grantee. You can't give somebody more than you have. Now that we've concluded this part on fee simple absolutes, let's focus on the three fee simple defeasible estates. Remember, these are estates that, unlike the fee simple absolute, can terminate on the happening of some future condition. If a fee simple defeasible estate is terminated, somebody else is going to be entitled to take possession of the land. Now, this may seem obvious to you, but we can state the reason for it. Our legal system doesn't permit land to become unowned or abandoned. In other words, there is always somebody who is entitled to possession of every parcel of land. So what that means is that if the fee simple defeasible estate comes to an end, somebody else has to be ready to take possession of it at that time. During the continuation of the fee simple defeasible estate, the person who is waiting and hoping and expecting perhaps to get the property when the fee simple defeasible comes to an end has a future interest. In other words, they have an interest in the land, but their possession is deferred until that future date when the fee simple defeasible estate comes to an end. So we can state as a truism that whenever somebody has a present interest that is less than a fee simple absolute in land, somebody else must have a future interest. That could be true of any interest in land that is less than a fee simple absolute. It would be true of a defeasible fee simple estate, as we said a moment ago. It would also be true of a life estate, a fee tail estate, a non-freehold estate such as a leasehold, an estate for years, a fixed term, a periodic, or an estate at will. All of those are the non-freehold estates. Whenever anybody has any one of those estates, somebody else must have a future interest. There might be more than one future interest, there might only be one, but there's sure to be at least one, because if the estate terminates, somebody else has to be entitled to take possession of the land. Now let's talk a little about creating future interests. Suppose O owns the land in fee simple absolute. O deeds it to A for life. We already know what A owns. We looked at that example before, and we concluded that A has a life estate in the land. However, we haven't said yet what O owns. The answer is that when A dies, A's life estate will come to an end, and because O hasn't given any future interest to anybody else, O has a future interest. So if an owner conveys a lesser estate in duration than he or she owns, the owner will have a future interest representing the right to get possession back again. Now, it's important to realize that future interests are actually owned in the present, and what's in the future is only possession. Let's take an example in which O deeds to A for life. We've already indicated that now O has a future interest that will take possession when A's life estate ends at A's death. But does O's future interest exist, and is it recognized by the law even though O doesn't have the right of possession yet? Well, the answer is that it definitely is, and there are a number of ways that we can convince ourselves that is true. First of all, O can recover for waste if A commits waste on the property. For example, if A burns down a house on the property or otherwise damages it, O will have an action against A for waste, even though O's not entitled to possession yet. A second example is that O can transfer O's interest. A future interest, in general, is perfectly transferable by deed or by will or by intestate succession, even though it isn't yet possessory and the person who owns it isn't entitled to possession yet. A third example is that if O does die, the property will pass to O's heirs or devisees, and that will happen despite the fact that they're not entitled to possession of the land yet. Finally, if the government decides to take the property in eminent domain, it has to pay compensation to the owners, and O, even though O's not entitled to possession yet, will be entitled to some of the compensation from the government's award. So, if we summarize what we've learned here, what is a future interest? We ought to call it a future estate probably, but we use the term future interest. It's an interest that somebody owns now, but with possession deferred until some future date. So it's not ownership in the future, it's only possession in the future. The ownership of it exists right now. Now we're ready to talk about defeasible fee estates. And we're going to make up a table about the 5 kinds of estates. And on our table, and I'd encourage you to make up your own rather than just copying it from the screen here, we're going to make 5 columns. On the first column on the left, we'll put the name of the defeasible fee estate. On the second, we'll put the typical words used to create the estate. In the third column, we'll put in who has the corresponding future interest, because remember, anytime anybody has a defeasible fee estate, somebody else must have a future interest. The fourth column will be the name of that future interest. And finally, in the last column, we'll answer the question, does the future interest take possession automatically when the condition on the defeasible fee estate is broken, or does it only take possession when its holder takes some action to get the property? So here is our table with the 5 columns: the name, the typical words, who has the future interest, what's the name of the future interest, and is it automatic, or does the holder of the future interest have to take action? Now on the far left-hand column, we're going to list the 3 kinds of fee simple defeasibles. We've already mentioned their names before. The first one's the fee simple determinable, the second, the fee simple on condition subsequent, and third, the fee simple subject to executory interest. So let's begin by focusing on the fee simple determinable. The typical words for this one are the words so long as or until. In other words, it could sound like this: I grant this land to A so long as the land is used as a residence, or so long as no animals are kept on the property, or so long as the house on the property continues to stand. Or instead of so long as, it could be until. I grant this property to A until animals are placed on the property, or until the house on the property is demolished. You get the idea. Now what about the next column? Who has the future interest? Well, the answer is the grantor. The person who gives out the fee simple determinable is the person who has the future interest, so that when the present interest, the fee simple determinable, comes to an end, it'll be the grantor who gets the property back. The future interest has a name. We call it a possibility of reverter. And in our final column, we ask ourselves, does the grantor get the property back automatically when the condition is broken, or does the grantor have to take action? And in this example, it's automatic. The fee simple determinable, when it ends, automatically the land reverts to the grantor without the grantor taking any action to get it back. The grantor automatically becomes entitled to possession again. In the second row, we'll look at the fee simple on condition subsequent. Here, the typical words are either the word condition or the word reenter. How would that sound in an actual example? I grant this land to A on the condition that the house on the property remains standing, or on the condition that no livestock is placed on the property. Or we can put it in terms of reentering. I grant this land to A, but if the house on the property is demolished, I may reenter and take the land back. So either way, we can use the word, either the word condition or the word reenter. Once again, who has the future interest? It's held by the grantor. What do we call the future interest? Well, there are 2 different names for it. It could either be called a right of entry or a power of termination. Either phrase is perfectly okay. Is it automatic, or does the grantor have to take action to get the property back? And with this one, this is the main difference from the first one, the fee simple determinable. Here, the grantor has to take action to get the property back. What do we mean by taking action? What sort of action should the grantor take? Well, there are several possibilities. The grantor could bring a suit to get possession back again. The grantor could send a notice to the person who had the fee simple on condition subsequent, telling them, move off, I'm taking the property back. The point is that the grantor has got to do something specific to indicate that the grantor wants the property back. It won't come back automatically. The third of the 3 fee simple defeasibles is the fee simple subject to executory interest. Once again, the usual words here are so long as or until, but they're not the only words. We need some additional words here, because who has the future interest? In this case, it's not the grantor, it's somebody else, and so we need some words that indicate who the future interest belongs to. How would this sound in an actual example? We could say to A, so long as the property is used as a residence, and if it is no longer so used, then to B. Or to A, until livestock is placed on the property, and when livestock is placed on the property, then to B. So we have to name the person with the future interest, because it isn't the grantor. In the first 2 types of defeasible fees, we simply assumed it was the grantor because no one else was named. But here, the person with the future interest has to be named. What's the name of the future interest? It's called an executory interest. And does it go to the third party automatically, or does the third party have to take action to get the property back? The answer is it's automatic. Now, if you have a symmetrical mind, you might be wondering why there isn't a fourth row on the chart, some kind of defeasible fee estate, which is in someone other than the grantor, but in which the person with the future interest has to take action to get the property back. The answer is that the common law simply never developed such an interest as that. The way they quaintly put it was there can be no condition in a stranger. In other words, you can't give a person other than the grantor a right to re-enter the land when the condition is broken. It has to go to the third party automatically rather than waiting for them to take some action. Now, we are going to go through a few defeasible fee estate examples and see what we think is created by each of these. The first one says to A, so long as no livestock are kept on the property. I think we talked about that one before. The key here is the phrase so long as, and that of course indicates that this is a fee simple determinable, and that's one that will terminate automatically if the condition is broken. The next one says to A, so long as no livestock are kept on the property, and then to B. Well, here the giveaway is that it says then to B. So the future interest isn't in the grantor, it's in a third party, and that means it must be a fee simple subject to executory interest. Once again, remember that it must pass to the third party automatically under that executory interest. To A, on the condition that the grantee builds a fence along the boundary of the property. Here the key is the word condition. Probably a court would construe this to be a fee simple subject to condition subsequent. Now, sometimes a few courts have said that to make it a fee simple on condition subsequent, you need some language about re-entry. In other words, language that would say to A, on the condition that the grantee builds a fence along the property, and if the grantee fails to do so, I, the grantor, can re-enter and take the property back. But most courts would probably say the language of re-entry is okay if you want to put it in, but it isn't essential to making this a fee simple on condition subsequent. This one says to A to revert to O if the property is used as a stable. Now don't be thrown off by this. It doesn't say so long as or until, but it does say to revert to. Well, that sounds automatic. It sounds as though the reversion is going to go back to O automatically, and therefore probably a court will find it's a fee simple determinable, even though it doesn't literally say so long as or until. Those phrases, so long as or until, are the typical phrases that are used, but other phrases that indicate an automatic reverter to the grantor will equally satisfy the need to find a fee simple determinable. This one says to A who covenants and agrees that the land will always be used as a residence. Now this is a little strange. It doesn't sound like any of the examples that we've talked about before. The answer is that it's not a defeasible fee estate at all. It's a fee simple absolute, and that language about the land not being used other than as a residence is simply a covenant that sort of rides on top of the fee simple absolute. Now, that raises a good question for us. How is the best way to control the use of land after it's sold? There are a couple of possibilities. The first possibility, and the one that we've been talking about, are defeasible fee estates. And we can sort of loosely call all of those conditions. The second way is the example we just looked at, where there's a covenant, a promise by the original buyers that they will restrict the use of the land in some way. Now, the point about the difference between these two is that they have totally different sets of remedies. We've already talked about the remedy for a defeasible fee estate violation of the condition. The remedy is termination of the estate. The estate will come to an end. On the other hand, if it's only a covenant, the estate doesn't come to an end. Instead, the person who has the right to enforce the covenant can seek either damages or an injunction against the breach of the covenant, but they can't declare the estate terminated and take the land back. So we have these two tools that could be used to control the future use of real estate after it's been sold, the defeasible fee estate or the covenant. What's the best method of controlling the use of residential property? Developers who build houses in subdivisions often want to restrict the use of the property that they sell. Some of the restrictions I'll just list here as examples. They want to restrict the number and types of animals that can be kept on the property, the color of the houses, the size of the houses and outbuildings, maintenance of landscaping. They want to put restrictions on the type and height of the fencing, and they may want to restrict parking of recreational vehicles. So is it better to use defeasible fee estates or better to use covenants for the purpose of making those limitations on the use of the property after it's been sold by the developer? Well, the answer is pretty obvious if you think about it from the point of view of the buyer. Naturally, you're willing to live with the restrictions, but if you should happen to violate one, would you prefer that you lose your property's title or that you be sued and enjoined or have to pay damages? Well, it's a no-brainer. Losing the property's title is sort of a draconian remedy. It's so severe that it doesn't really fit the crime, so to speak. And so almost always today, developers use covenants rather than defeasible fee estates to limit the use of property that they sell. What this means is that defeasible fee estates are not very often used anymore. I want to give you an example of a Montana case where some people named Woods transferred some property to the county, and they put in the deed, quote, "This is for the purpose of constructing and maintaining thereon a county hospital." You'll notice that it says for the purpose of. It doesn't have any words that make this a defeasible fee. It doesn't say so long as or until. It doesn't say on the condition that, or it doesn't say if the county doesn't use it as a hospital, we can re-enter and take the land back. There are no words making this a fee simple defeasible estate. The words about use or purpose alone, the court said, won't create a defeasible fee estate. So let's take a look at some examples and see if we can tell the differences among them. 2A, so long as used as a hospital. Well, that sounds like a fee simple determinable, no problem. 2A, on the condition that the land always be used as a hospital. That's probably a fee simple on condition subsequent. 2A, but if the land is not used as a hospital, to revert to the grantor. Once again, that sounds automatic and therefore probably is going to be construed as a fee simple determinable. 2A, but if it's not used as a hospital, the property to pass automatically to B. That's pretty clearly a fee simple subject to executory interest, since the future interest is held by somebody other than the grantor, and it is going to pass to them automatically. But 2A, for use as a hospital, well, there aren't any words indicating that the estate will terminate if it's no longer used as a hospital, so that one is almost certainly a fee simple absolute. How about this one? 2A, on the condition that the land always be used as a hospital, and if not, to revert to the grantor. Now this one's quite interesting because it has one phrase, on the condition that seems to suggest a fee simple on condition subsequent. And it has another phrase, to revert to, which sounds automatic and seems to indicate a fee simple determinable. So where we have signposts in the language that point in both directions, what should we do? Well, the courts have developed an answer to that question. What they have done is to create what we call constructional preferences if there's ambiguity in the wording. And here's the way the courts prefer to find. First of all, if it's possible, they'd prefer to find a fee simple absolute. So if it's not pretty clear that the fee simple estate is intended to come to an end or terminate in the future, they may find a fee simple absolute. Second, they'd prefer to find a fee simple absolute with a covenant. The covenant seems to be, as we've indicated, a less draconian or extreme remedy than the remedy for a fee simple defeasible, and therefore it's preferable. Third, the fee simple on condition subsequent is considered to be next in preference. And finally, the least preferred is the fee simple determinable. Why the difference between the two? Well, the reason seems to be that the fee simple determinable is so sort of inexorable, it's going to happen come hell or high water, and therefore will surely defeat the fee simple estate, whereas the fee simple on condition subsequent might or might not defeat the fee simple estate if there's a breaking of the condition, depending on whether the grantor takes any action to get the property back. So it's less extreme. Do these preferences make sense if the goal is to free the land from restrictions? Well, on the face of it, they do seem to make sense. But I'm going to suggest to you that actually the two final ones are backward and that they should be in the other order. Now, I'd like to show you why I think the constructional preferences we looked at on the previous slide are not really quite right. Let's assume that A owns some land as a fee simple defeasible. It could be any one of the three kinds, and A breaches the condition in the fee simple defeasible, but A doesn't move off the land, and the holder of the future interest doesn't take any action against A to get A off the land. By the way, would you guess that's a pretty common experience? Well, it turns out it's extremely common. In many cases, the person with the future interest has forgotten that they had a future interest, or they've become senile or have Alzheimer's. They don't remember that they have a future interest. They may even have died, and the future interest may have passed to somebody else, an heir, who doesn't know that the future interest passed to them. So it's actually very, very common for the condition to be broken and nobody with a future interest to take any action against the person with the defeasible fee estate. So the question before us is, when does the person with the defeasible fee estate become an adverse possessor? Let's assume we have a 10-year adverse possession statute. Suppose, first of all, it's a fee simple determinable. Well, a fee simple determinable we know terminates automatically when the condition is broken, and the person with the future interest, the possibility of reverter, immediately becomes entitled to possession. That means that if the person with the fee simple determinable remains on the property, they're now trespassing. And because they're trespassing, they're an adverse possessor, and after 10 more years, they will have acquired full title to the real estate. And by full title, what I mean is that they will have a fee simple absolute, and the person with the future interest will be cut off and terminated. There won't be any future interest anymore. In effect, by virtue of adverse possession, the fee simple determinable has been converted into a fee simple absolute. The second possibility is that it was a fee simple subject to executory interest. Here, the future interest is held by a third party, but otherwise it's the same analysis, because the fee simple subject to executory interest once again will terminate automatically when the condition's broken. The future interest holder becomes automatically entitled to possession, and once again the person with the fee simple subject to executory interest is now a trespasser, and after 10 years of adverse possession will acquire full title. The third possibility is that it's a fee simple on condition subsequent. And here the analysis is completely different, because here, with a fee simple on condition subsequent, the estate doesn't terminate merely because the condition's broken. It will only terminate if the person with the future interest, the right of entry or possibility of reverter, takes some action. So if no action is taken, the estate simply continues to exist in the person who held the fee simple. They get to remain on the property indefinitely into the future until the future interest holder takes some action. They're not trespassing, they're not an adverse possessor, and therefore they never can cut off the future interest by virtue of adverse possession. And you might say, is there any limit on how long this can go on before the future interest holder loses the right to exercise the right of entry or power of termination. And some courts have indicated that the future interest in a fee simple on condition subsequent does have to be exercised within some reasonable time after the holder of the future interest learns that the condition has been broken. What's a reasonable time? Well, my guess is that it might be a number of years. We don't know for sure. There really isn't much case law on that. With this information in mind, let's go back to the constructional preferences that we looked at on the previous slide. If the goal of the courts in cases of ambiguous wording is to free up titles to land by turning them into fee simple absolutes, then I would suggest that the last two on this list are in the wrong order. That is, that fee simple determinables are preferable to fee simples subject to condition subsequent. The reason is that the fee simple determinable is much more likely to be turned into a fee simple absolute by virtue of adverse possession, as we've just seen. So if I had my way about it, I would take the fee simple determinable and put it before the fee simple on condition subsequent in terms of preferences. But that's only my opinion, and the courts don't agree with it. By the way, remember that these preferences apply only in cases of ambiguity. If the wording is clear, the preferences don't have any relevance and we simply follow the wording. Finally, consider whether we ought not to simply say what we mean. For example, if we're going to give a fee simple determinable, we use the language to A so long as no liquor is sold on the premises. Why not then follow that up by simply stating in the document itself, this gives a fee simple determinable. That ought to be perfectly permissible. There's nothing wrong with spelling it out that way, and it ought to eliminate any possible ambiguity. On the other hand, you have to know what you're doing. What you don't want to do is use language that gives one form of fee simple and then calling it a different form of fee simple. If you do that, you'll create a horrible ambiguity and almost ensure that there'll be litigation. That would be a bad result. That concludes our discussion of the fee simple absolute and fee simple defeasible estates. In our next video, we'll cover the life estate and the fee tail estate. If you have questions or comments, email profdale01@gmail.com. And thanks for watching.